Dialog Box 1.1 1.30 DeRosiers and Biddle 2004, 9 argue that the criminal law should be reserved for the most serious harms. However, Brown 2009 suggests inadequate limits have been placed on the types of behavior that can be legally defined as crimes. Extensive research highlights how governments often respond to many actual and perceived social problems by expanding the criminal law to cover more behaviors or introducing harsher criminal penalties. This form of overcriminalization, Ashworth and Zedner 2008, results in sweeping reforms to key areas of crime and justice policy, often without considering research that identifies various harms caused by these policies or the routine operation of the criminal justice system. Brereton 1996, 83. The reflex application of criminal law to deal with complex social issues is highly problematic. DeRosiers and Biddle 2004, 9. Expanded legal definitions of crime tend to prohibit an increasing number of less serious or harmful behaviors, which extends the stigma of a criminal label to more people. The resulting net widening effect, Walker 2005, 223, stems from broader definitions of crime capturing behaviors that might not be deemed criminal by many sectors of the community. This pattern makes it harder for the criminal justice system to promote social reintegration. Braithwaite 1989. From many of the secondary or collateral effects of a criminal conviction that include restrictions on free movement, the inability to undertake certain forms of employment. Colgate Love, Roberts and Klingele 2016, and repeat exposure to police surveillance to prevent reoffending. Cunning and Torrey 2016, Blagg and Anthony 2019. While these processes of criminalization might be politically appealing due to their presumed effectiveness in reducing social harm, they are not necessarily a desirable focus for the state's policing, legal and punishment resources. Mitselegas 2014. Net widening is linked to pre-crime. McCulloch and Wilson 2015, Zedner 2007. Pre-crime attempts to identify and prohibit the early signs of criminal behavior to prevent more serious criminal activity in future. Pre-crime laws commonly target attempts or conspiracies to commit serious crimes, such as terrorism offenses. McCulloch and Pickering 2009. The emphasis on pre-crime challenges the historically reactive focus of the criminal law, which was generally only applied to investigate, prosecute, and punish unlawful behavior that had already occurred. Bentham 2001. Preemptive pre-crime laws commonly remove many due process protections associated with the presumption of innocence, including the right to silence, the right to a fair trial, and the presumption in favor of bail. McCulloch and Pickering 2009, 632. Even though pre-crime laws aim to promote enhanced security and community safety, they ultimately target the risks of harmful conduct by identifying behavioral signs that aim to predict and preempt the likelihood a person might commit a serious crime in the future. McCulloch and Wilson 2015, 3, Harcourt 2007. Critical criminologists argue the preemptive and predictive emphasis of pre-crime laws unacceptably reshapes the legal definition of crime by targeting vulnerable individuals who have limited capacity to understand the consequences of their actions or challenge the enforcement of these laws.